What if you built your software, shipped it, gained traction, and then found out that you weren't properly protected and lost $10 million in exit valuation? Not 10 million in revenue, 10 million in valuation, which could be 10 million out of your bank account when you exit. This is not rare. I see versions of this all the time, especially with fast-moving tech founders who built quickly, hired contractors, used AI tools, and assumed that the legal side was handled. And the nightmare is that you don't discover this while you're building. You discover it later when there's money on the table. I'm Rich Goldstein. I help tech founders protect what they build and turn IP into leverage. If you're building software right now, bootstrapped, funded, or ready to raise, this is the IP protection breakdown that you need before diligence exposes the gaps. When founders lose $10 million from weak IP protection, this is what it actually looks like. Number one, a lower offer based on a lower multiple because the business isn't as solid without the IP. Number two, the buyer renegotiates the price and reduces the price during due diligence because the ownership of IP isn't clear. Number three, an investor changes the terms or even walks away from the deal because the risk is too high. Number four, a deal stalls while lawyers force a cleanup, if a cleanup is even possible in that circumstance. And ultimately, that cleanup is leverage that's used against you. IP gaps don't just create risk. They give leverage to the other side in renegotiating in a way that's going to cost you value. The 6 IP gaps that create massive valuation loss. Gap number one, you can't prove that the company actually owns the IP. When there's confusion over the ownership of the IP, this is a big red flag that can come up during due diligence. And the business owners might not even know that the IP is in the name of a former partner, or maybe it's in the name of engineers or employees at the company. The fix is to make sure that all inventors have assigned their rights over to the corporation. And it's also to make sure that the trademarks are properly owned. Gap number two, contractors worked on core code without airtight assignment of their rights. When you're in the middle of a deal and a contractor is asserting ownership rights over your IP, over your technology, this can cause a big mess that requires a cleanup and possibly a renegotiation. In some cases, that renegotiation is with the contractor, where you have to cut them into your acquisition deal in order to save the acquisition deal. One of the ways to handle this is to fix it ahead of time and make sure that any contract with a contractor includes a strong IP assignment clause. Gap number three, open source landmines. If you use open source material in building your product, then whatever you build is subject to what your true open source rights are. And people acquiring a business don't like when they're acquiring rights to something that are then subject to other people's rights. You have to be careful because the rights that you have in that material may be in question at the time of acquisition. Gap number four, trade secrets treated casually. Safeguards that you take to keep that information a secret is what establishes the trade secret protection and what establishes the value in your trade secrets. But if you don't have the safeguards in place that are necessary to keep the information secret, then competitors can casually copy your information, and the value of what you think is valuable to your business, what you think is going to drive an acquisition, can diminish to zero immediately. Gap number five, no patent strategy for the part that's actually defensible. People often think in terms of, well, let's file a couple of patent applications on this technology. But they don't have a clear IP strategy to know what they are aiming their protection at, to know what the novelty is, what's the part that is going to be found to be unique at the United States Patent Office and is also going to give them leverage over the marketplace. Because that's what's going to create value for acquisition, having valuable patents that were well thought out to be directed towards what's defensible. Gap number six, no buyer-ready IP narrative. Even good IP gets undervalued. If you can't present a narrative to the buyer that shows how having this IP really leads to the increase in safety for them as they jump in to buy this business, the premium multiple for your IP only comes when you could demonstrate it. If you want to prevent a $10 million valuation loss, you need a simple system. You want company-controlled repos, domains, and cloud accounts. You want signed IP assignments from anyone who's touched the product development. You want a contractor closeout checklist with deliverables, access removal, and confirmation. You want OSS scanning and an OSS log. You want trade secret controls. Who can access what, when it's accessed, and have all of that well documented. You want patent strategy to be tied to the core mechanism, to the core novelty, to the defensible part of what's protectable. You want to have a one-page IP narrative prepared that you could present for due diligence. If you're building software and you're moving fast, don't let speed create an ownership mess that costs you millions in leverage. Click below to book an IP protection and patent strategy session. We'll identify the highest risk gaps, prioritize the fixes, and map a protection plan that holds up in funding, licensing, or acquisition. And if you need patents, strategy drafting, filing, or strengthening an existing portfolio, my team and I can handle your patent needs end to end.